what do you think is going to be the practical impact? Practical impact on those policies in the short term and then in the long term, because they might be different, right?
Right. And I think, maybe if we're, just to step back and talk sort of more broadly about what the impact of the decision is, I think there's the narrow impact, right? There's the, to take us back to what the Bruin case was about, right? There's the impact on permitting, on concealed carry permits, right? So you've already seen, I think, all of the may issue, or the states that the court categorized as may issue, either like New York, passing a new law saying we're getting rid of proper cause. We're also doing a lot of other things, which we can get into.
And actually,
go ahead.
Well, go ahead. Sorry, you finish your point, but I want you to ask a follow up on that.
Yeah, sure. My point was simply, you've seen New York do that. I think every other state that the court placed in that category has done something similar, not necessarily amending their laws formally, but having, the state attorney general has issued an opinion letter saying we're not enforcing our proper cause analog. But I think, there's definitely still, there are still outstanding questions on even concealed carry permits, right? There are moral character or suitable person requirements in, I think all of the may issue states have them, and certainly some of the shall issue states did as well, right? So to what extent do those allow for discretion? Are those still okay? It seems like the court says yes, but where is the line, and what are states still allowed to consider in terms of the reason that a person wants to get a permit?
That's interesting. You think that those sort of good moral character clauses aren't functionally identical to the proper clause? I understand that in one, you have to prove you need this permit for a particular reason, but the other one, you have to prove that you're a good person or whatever that means. But they both seem like clearly completely subjective, which appeared to be the main issue with the good reason clause in this case, right?
Right. And I think that's sort of that's the interesting twist on this opinion, is that, the court says these shall issue jurisdictions don't have to make changes, but some of them have these types of requirements in place, right? So it's not really clear what to make of that or where we go from there. And I think
it comes
we'll see
down
some
to
litigation there.
Right? Yeah.
I think that's probably right. I think for a lot of the permits, there's been, again, we can talk, if you want, we can talk more about the New York law, and I've written a post about that as well. But, I think a lot of this stuff will play out as an as-applied challenge. And that's what we see the court saying in Bruin, that even if you implement shall issue, you sort of get your permit system the way that it needs to be, according to the court, you can still have an as-applied challenge, which is not anything unusual, right? If it's applied in a way that is too cumbersome or has exorbitant fees for applicants, stuff like that.
Right. Yeah, I think that probably will happen in a lot of these former may issue states. You'll see a lot of as-applied challenges over wait times and cost and so on and so forth. And those will probably be a little more dicey as to how they'll come out. I think, but some of these laws that have been passed in response to the ruling, it feels to me at least that the outcome is far less dicey, and that these are just sort of blatantly unconstitutional things that are intentionally thumbing their nose at the Supreme Court. But I'm interested in your perspective, like this, the New York laws that's basically make everywhere a sensitive area. The governor had a quote saying, when she was asked where it would be legal to continue to carry, and she said, presumably some streets, and basically nowhere else. They made the entirety of Times Square a gun-free zone. They've inverted. This one's interesting because it's completely novel. I've never heard of anyone trying it this way before, but they've inverted things to where all public businesses are presumptively gun-free zones and have to put up signs saying they want people to carry there. How do you think these these new laws that are passed in that vein are going to actually perform in court?
Sure. Yeah, I mean, it's a great question. It's a question that I'm sure there have been legal challenges already to New York's to the law that New York passed. Those will take some time, I would imagine, to work their way through the court system. But I think to take the sensitive places. The designation of sensitive places as an example. I mean, I think that's maybe the most high profile part of this law that, as you said, New York has a very expansive list, right? They include, Times Square, bars, park, zoos. But I mean, there are just it's a very,
Public
very long
transit.
list. Public transit.
Yeah.
Yep. And, it's not, there's not, as I said, there's not a ton of guidance in Bruin about the sensitive places issue. The court discusses it briefly, but this is going to come down to at what level of generality are courts looking to history, right? Are they, if you take a narrow view of the places that Justice Thomas listed, I think it was legislative assemblies, courthouses, polling places, those are all places that have a close relationship to government, political actions, voting, right? Maybe that's kind of the defining principle there. But you can think of other ways that you could do this analogical reasoning, right? You could say places of public assembly. The court seems to cast doubt on that, right? Because Manhattan can't be a sensitive place just because it's crowded. You can think about the proximity of law enforcement, the availability of law enforcement in a certain place. It's interesting, even within the brief passage in Bruin. There's not really an explanation of why the historical sensitive places that are identified would support banning guns in schools, right? I mean, that's something that is in Heller. I think, or this is something that the court has been saying that banning guns in schools is okay. But again, it's going to depend on the level of generality at which a judge looks to history, right? Because there are historical laws out there. I think there's a fair amount actually from the South and the West in the 1800s, late 1800s, saying you can't bring guns to places where people assemble, and then they list certain places, right? If you go further back, there are prohibitions on carrying guns in fairs and markets in England, right? So it's simply going to be a question of how do you do that analogical reasoning, and there's not a ton in Bruin that we can go off of to really predict.